Nia Osei had been a law clerk for 11 days when she learned that the most dangerous word in a courtroom was obviously. She was stationed beside Judge Adiz Ren's bench in Family Division Courtroom 2, Merritt County Courthouse, on a Tuesday in early March when the guardianship petition for the two Lassiter children was called. Nia had the file. She had read it on the train, twice, once for the facts and once because something in it had stayed with her, though she could not yet name what. She knew the grandmother's name, Dorothea Lassiter, 68, retired pediatric home care nurse, petitioning for full guardianship of her late daughter's two children, ages 7 and 9. She knew the daughter had died 11 weeks ago, and that the grandmother had filed the petition herself, by hand, at the clerk's window, the following week. The children were in the hall with their guardian ad litem, a woman named Forsyth who had brought them juice boxes and a deck of cards. They were safe. They were not part of what was about to happen in here. What Nia had not yet learned was how a room could agree on something wrong before a single piece of evidence was entered. The court-appointed family services evaluator was a man named Reston, middle 50s, trim suit, the practiced composure of someone who had done this 400 times and expected the 401st to go the same way. He took the stand with his bound report tucked under one arm and set it on the rail in front of him the way a carpenter sets down a level, a tool, and a reliable one. He had conducted his evaluation 6 days after the death of Dorothea Lassiter's daughter. A single intake interview, 90 minutes, in the grandmother's kitchen. Mrs. Lassiter, Reston said, reading from the report in a measured voice that carried easily to the back of the room, presented as emotionally compromised. She cried at multiple points during the interview. She was unable to articulate a structured routine for the children's schooling. Her responses were fragmented in ways consistent with acute grief, which, while understandable, raises serious concerns about her current capacity for primary parenting. Nia glanced at the grandmother. Dorothea Lassiter sat at the petitioner's table in a gray wool blazer and a white blouse, her hands folded on the table in front of her, her eyes on the evaluator. She did not move. She did not flinch. The only sign that she had heard was the slight, deliberate way she drew one breath and held it a beat too long before releasing it. Not grief, Nia thought. Something older than grief. Something that had been through grief and come out the other side carrying its composure like a practiced thing. Reston continued. He characterized her home as marginal for placement, a term he did not define, and noted that her nursing background, while admirable, was not directly applicable to the supervisory demands of full-time guardianship. He spoke about the children's need for stability as though it were a specialized subject the grandmother had never considered, as though the word stability had not lived in this woman's body for 68 years. He recommended, without qualification, that the children be placed with a licensed foster agency pending a longer evaluation period, a process he estimated would take 4 to 6 months. He said this the way a contractor estimates a roof job, competently, without sentimentality, as though the 4 to 6 months were a technical specification rather than a winter of a child's life. His voice carried no doubt. The room absorbed it the way rooms absorb things that sound like expertise, quietly, and without checking. Nia found herself nodding slightly, and then caught herself doing it and stopped. She had read the file. She knew the grandmother had petitioned. She knew the attorney sitting beside her, a compact woman named Brielle Cates, who had the unhurried stillness of someone who had been waiting for this moment since she first read Reston's report, was about to say something. And yet Nia had nodded. The certainty in Reston's voice had pulled it out of her before she had thought to question it. That bothered her for the rest of the morning. Cates rose when Reston finished. Your Honor, the petitioner moves to admit the State Child Welfare Registry file for Dorothea Lassiter. We request the court order its production from the county clerk's office. Reston did not quite roll his eyes. He came close. The registry file is unnecessary in this context, he said, without being asked. My evaluation was conducted in accordance with standard departmental protocol. Judge Wren looked at him. She was a deliberate woman, late 50s, reading glasses on a chain, the kind of stillness that does not telegraph patience so much as the quiet suspension of it. Was the registry file pulled as part of your evaluation, Mr. Reston? A pause. Small, but there. It is not a required component of the intake evaluation at this stage. That wasn't what I asked. Judge Wren turned to the clerk by the door. Pull the State Child Welfare Registry file for Dorothea Lassiter from the county records office. Full file, certified copy. She looked at the clock on the wall. We'll recess 14 minutes. The gavel came down. The room exhaled. Nia watched Reston. He gathered his report from the rail, straightened it, set it down again. He looked at the table in front of him. He did not look at the petitioner's table. That, Nia thought, was the first crack, not in his composure exactly, but in its architecture. The way a man stops meeting eyes when he has begun to calculate. Across the room, Dorothea Lassiter spoke quietly to her attorney. Cates wrote something on a legal pad. The grandmother nodded once and folded her hands again. There was nothing in her posture that suggested she was waiting to be vindicated. There was nothing that suggested she had any doubt she would be. The difference between those two things, Nia was learning, was the whole distance between dignity and performance. On the other side of the gallery, two observers from the County Family Services office sat with their own notepads. One of them had been writing steadily since Reston took the stand. She had stopped writing when Cates moved to admit the registry file. Now she was watching the door the registry clerk had disappeared through, and her pen was still. The 14 minutes passed. They felt longer. The registry clerk came in at minute 12 with a certified file jacket, sealed, and handed it to the court clerk, who handed it to Judge Wren. The courtroom settled. Wren opened the file and read for a moment without speaking. Her expression did not change. It deepened, the way a face deepens when it is reading something that reorders the room. She looked up. "I'm going to read this into the record," she began. Dorothea Lassiter had held an active foster care license in the state of Merit for 19 consecutive years, renewed without interruption, without a single formal complaint filed. She had fostered 21 children over that period, 11 of them long-term placements exceeding 12 months, 6 of them adoptions successfully finalized by her and her late husband. Her most recent home inspection, conducted 8 weeks before the hearing, not the kitchen interview Reston had visited, had returned a rating of exemplary across all 14 categories. Her pediatric home care nursing license was current and unrestricted, with a specialization in developmental care that the state licensing board had recognized as a continuing education credential in child welfare. And then Judge Wren paused, turned a page, and read the line that changed the room. Mrs. Lassiter was awarded the State Excellence in Family Preservation Commendation in the year prior to this hearing, the highest commendation the Department of Child and Family Services issues. It is given to one foster caregiver per year in this county. The citation reads, "For 19 years of sustained, exceptional commitment to the welfare and stability of children in the state's care." The room did not make a sound. Nia looked at Reston. He had stopped touching his report. His hands were flat on the table. He was looking at a point somewhere between the table and the floor, the particular direction a person looks when they are not looking at anything, because looking at anything would require them to absorb what had just happened. He had evaluated a woman who held the state's highest foster care honor. He had characterized her as emotionally compromised, and her home as marginal. He had done so without pulling the mandatory registry file that would have told him, in 19 years of documented data, exactly who she was. And he had delivered that evaluation in open court, in his assured carrying voice, while the room nodded. Judge Wren set the file down. "Mr. Reston. The departmental protocol for a guardianship evaluation at this proceeding level requires a current registry pull as a mandatory component. Is that your understanding of the protocol?" A longer pause this time. "It is. And you did not pull it?" "No." "Then your evaluation is procedurally deficient on its face." Wren turned to the court clerk. "The evaluator's written recommendation is struck from the record. I'm entering a finding of inadequate evaluation on the docket. The Professional Standards Division of the Department of Child and Family Services will receive a copy of this finding and this transcript today." She removed her reading glasses and let them rest on the chain at her chest. When she looked at Reston, it was not with anger. It was with the measured attention of someone making sure a thing is understood. 19 years of documented service. A current exemplary inspection. The state's highest commendation. All of it in the file you were required to pull. You conducted an evaluation of a woman's fitness as a guardian while the record of her qualification sat 8 minutes from this courtroom in the county records office. That record will now speak for itself. She put her glasses back on. "You are excused." He gathered his report. He did not look at the petitioner's table as he went. The family services observer in the gallery had stopped writing entirely. She capped her pen. What happened next took less time than the 14-minute recess. Kate submitted the registry file as Exhibit 1. She submitted the commendation citation as Exhibit 2. She submitted the home inspection as Exhibit 3. Judge Wren reviewed each in turn, asked 2 brief questions about school enrollment plans, which Dorothea Lassiter answered without notes, in the calm, organized cadence of someone who had been planning for her grandchildren's schooling since the week of her daughter's funeral, and then set her pen down. The court finds the petitioner fully qualified. Guardianship of the 2 Lassiter children is granted, effective today, on the record. Nia did not realize she had been holding her breath until she let it go. Dorothea Lassiter did not cry. She thanked her attorney in a voice too low for the gallery to hear. She signed the documents the clerk brought over. She received the certified copy of the guardianship order, folded it once with the particular care of someone who knows the weight of a piece of paper, and put it in her bag. Then she stood, straightened her blazer, and walked toward the door of courtroom 2 at the same unhurried pace at which she had entered it. In the hall, the guardian ad litem, Forsyth, saw her coming and touched the older of the 2 children on the shoulder. The child looked up. Dorothea Lassiter covered the last few steps between them and opened her arms, and both children went into them without a word, because they already knew from the look on her face what the answer was. There was no theater. There was no announcement. There was a grandmother and 2 children standing in a courthouse hallway in early March, and that was enough. Back inside courtroom 2, Nia Osei pulled a notepad from her bag, not the official one, the personal one she carried for exactly nothing in particular, and wrote herself 4 words in the margin at the top of an otherwise blank page. She wrote, "Pull the file first." She was not writing it as a legal reminder. She understood that. She was writing it as something closer to a rule for how to move through a room where people are being sized up by people who believe their own certainty. She had nodded. She had felt the pull of the voice that knew what it was talking about, and she had begun to agree before she had looked at what was in front of her. Reston's voice had been confident. Dorothea Lassiter's hands had been folded on the table. And Nia had found herself pulled toward the confidence, because confidence announces itself and composure does not. She thought about that for a long time after the courtroom cleared. She thought about the 19 years in the registry file, the 21 children, the 6 adoptions, the exemplary inspection, the commendation, all of it sitting in the county records office 8 minutes from where Reston had sat and read his evaluation in his certain voice. She thought about the grandmother's one long breath while he read, the way she had taken it and let it go without flinching, as if she had known the file existed and had decided a long time ago that the truth could be patient because she had been patient longer. That was what composure was, Nia thought. Not the absence of feeling. Not the performance of calm. It was the decision to let the record speak, because the record was correct, and because a person who is correct does not need to raise her voice to be heard in the end. She closed her notepad, capped her pen, and went to pull the next file for the afternoon session.